The issue here is the ability of the courts to consider the factors that we believe to be most relevant. The current law allows the courts only to consider the amount of the loss, and that has been set so high so that virtually any public company's CEO convicted of almost any securities offense faces a guideline sentence of life without possibility of parole. So we're talking about taking nonviolent first-time offenders and treating them as if they had killed someone. And there may be some circumstances in which sentences like that are appropriate. What our group is advocating, and I'm working now on behalf of the American Bar Association, is to allow judges to consider more than just the loss. We think it's important to consider whether the defendant got the money, whether the defendant was even trying to get the money, how long did it go on, how sophisticated was it.
But surely they take all of those things into account already, don't they? Jim, they must take all of those factors into account already.
They do not and cannot under the guidelines. The guidelines consider only the amount of the loss.
Got it.
And the number of victims.
Before we bring in the panel, now, and I understand you think that there's no way these sentences should be lightened. Is that right?
That's right. I mean, that's one of the dumbest things I've ever heard. I mean, we know that long prison sentences have a deterrent prophylactic impact on white-collar criminals because these guys are rational, they think about stuff, and they don't want to spend the next 20 years in a 10-foot by 10-foot prison cell. And if you take a look at, Bernie Ebbers, if you take a look at Jeff Skilling, the guys who spend decades in prison, they've spent decades in prisons, and we've had zero major accounting scandals since then. So to say that we should take other things into consideration, it's a joke.
Zero major accounting scandals since then. I mean, I hope you're right, but I feel like that